This is Elliot Schlissel, father's rights lawyer. Today I'm going to talk to you about a case involving a wife who sought to set aside her prenuptial agreement. This case was in front of Judge Jeffrey Goodstein, who sits in a matrimonial part in Nassau County. Now, in this case, 10 years earlier, the parties had entered into a prenuptial agreement. The wife brought an action to set aside the prenuptial agreement. She claimed, through her attorneys, the prenuptial agreement was invalid, that there had been fraud, there was a breach of contract, there was coercion, and all types of other claims. She claimed her husband had promised her the agreement would no longer be in effect after 7 years of marriage. She claimed she was coerced into signing the agreement, and she did not have an opportunity to be represented by independent counsel. The agreement was executed a few days before the wedding took place. The wife also claimed the husband breached the agreement. Judge Goodstein, after some consideration, wrote a decision, and his decision stated that the wife failed to produce enough documentary evidence to prove her case. He found she did not establish coercion, breach of contract, or lack of independent counsel. He did take into consideration that the wife failed to provide corroborating testimony to her allegations. She found there was some ambiguity with regard to the issue of life insurance, and thereafter ruled that the agreement was valid except for the life insurance clause. Now, before you enter into a prenuptial agreement, you should always be represented by counsel, discuss the terms with your lawyer, and be comfortable with these terms. This is Elliot Schlissel, father's rights lawyer, signing off.